Mr. Chairman.
Hold on, Council Lukwago. JA advise on that.
I wanted to make a case for that particular matter, Mr. Chairman, before he comes in. So if I may be allowed, Mr. Chairman, it's a matter of law, it's a matter which touches the Constitution. So we have a prayer to make, Mr. Chairman.
And that's why this is my advisor. It's about law. Let him advise and then
Mr. Chairman, the issue is about making a prayer for a constitutional reference. And we pray that we be permitted to do so, Mr. Chairman. And if it's a matter of constitution, it takes precedence over any other issue. And that's the reason we are seeking for your audience to permit us to make a case for a constitutional reference led by my colleague here, Counsel Kalibala. That is our prayer, Mr. Chairman, that we make a case for constitutional reference. And if you do permit, Counsel Kalibala will proceed to take lead in this, in light of the ruling you have made, Mr. Chairman. And I would like to emphasize that where a constitutional matter has been raised, it takes precedence over any other matter. So we beg that you permit us, Mr. Chairman, to proceed to urge out the case for a constitutional reference.
I have no problem with your submission, Council, but what I'm saying, he advises the court on law matters which we are going to raise. I have finished the ruling, let him advise, and then he will be given time if it is allowed. I don't know what you are laughing, and I don't understand what it means, because
I think, sir, if he has any points to raise on matters of law, the procedure is that you can urge out your case, the state will respond, and this court will also rule on that matter, whether what you have raised requires a reference to the Constitutional Court or not. So you can proceed.
Excuse me, I wanted just to know, why are you laughing? Hold on. Unless you don't know his role, maybe. He has advised, that's what I wanted. And I think the council can proceed. I think, go ahead.
Thank you, Honorable Chair. Honorable members, following the ruling that has just been delivered, our instructions are to seek for a reference on a number of matters. The ruling has itself interpreted articles of the Constitution and found them inapplicable. That role is a role that is reserved for only one court in this land, the Constitutional court. But Mr. Chairman, I want to preface my application for a reference by taking the court to Article 208 of the Constitution. That article, Mr. Chairman, establishes the UPDF. And it spells out a number of very good attributes for the UPDF: patriotic, professional, disciplined, and so on. Those attributes, in fact, distinguish the UPDF from other previous forces of a similar nature that we had. So they are quite impressionable, they are quite useful. We think that they are amazing attributes to have. I have found them also on the UPDF website. So the UPDF itself is aware of what these attributes are. One of the most important attributes in Article 208 is that the UPDF is subordinate to the civilian authority. Established under the Constitution. Mr. Chairman, what that means is simply that the force, its members, and its organs are all subordinate to civilian authority. And in fact, the courts, I'll be referring you to a number of cases, the courts have made pronouncements to that effect. And we contend that in the finding that you have jurisdiction in this matter, the General Court Martial is putting itself above civilian authority. And I will explain what that means. Mr. Chairman, our Constitution is a very, very important document to us. The preamble tells us all the things that were wrong with this country. It tells us the things we aspire to. And it also says these are the ideals we should pursue. And in saying so, it wasn't about 1995 when it was promulgated, but it was to continue up to eternity. That same document also gave us a chapter 4, which covers many articles on human rights and so on. I'm going to refer to 28 shortly. But the force, the UPDF, must live by what the Constitution declares. In addition to what I have just said, that same Constitution says that the rights of all persons, including accused persons, are inherent, so they are not granted by anybody, not any organ, not any person. They are inherent. And they can only be taken away in the manner that the Constitution has said they can be taken away. So I will start with Article 28 on the right to a fair hearing. Honorable Chair, the right to a fair hearing has been described as that Article 28 as a culmination of Uganda's struggles against forces of tyranny, oppression, and exploitation that brought about unconstitutionality and political instability. It is one of those articles that cannot be derogated from. So there are no circumstances at all under which one can ignore or disapply or fail to observe that specific article. And one of the most important aspects of that article is in Article 28:12. Article 28:12 provides that except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed by law. The emphasis is on the defined. It is what we are dealing with. So Article 28:12 requires that every offense is clear. The idea around definition is that when you read it, you know what conduct amounts to an offense and what conduct does not amount to an offense. And it cannot be derogated from. So if we have a situation where it's not clear, then we are derogating from Article 28:12. Mr. Chairman, the charge sheet has an offense which is described as offenses related to security. It is contrary to Section 128, 1F of the UPDF Act. Perhaps let me read it out. Paragraph F is to the effect that if you do or omit to do anything with intent to prejudice the security of the defense forces, you commit an offense. If you do or omit to do anything. So you could walk into, as a civilian, I could walk into a military barracks. I could be charged with that offense. I could be charged with that offense. If I am a cook and I decide that the porridge I have been asked to make for this morning has, in my assessment, issues, and I refuse to make the porridge, and as a result people go out in a unit and they are hungry and they are ambushed and they have no energy to fight, I can be charged with that offense and I can be put to death. That is if I refuse. If I don't refuse and I make the same porridge, knowing that the portion may have an issue, but we have to eat, people have to go out, it's urgent, and people go out and they develop running stomachs, I can be charged with that offense and put to death. If you do anything, if you omit to do anything. Now, Mr. Chairman, it would be useful if the court looked, while it is considering this application, looked at the rest of the paragraphs, 128(1)(a) to E, because they are very specific as to what it is a person could do. Disclosing by word of mouth or a document information to the enemy, that is clear. Discussing confidential information is clear. Giving a password to somebody who is not authorized, that's clear. And then at the end of that whole section, if you do anything or omit to do anything, Mr. Chairman, I contend that the offense is not defined. Article 2812 deals with the gist of it. The purpose for it is to ensure there is no vagueness. So it is the constitutional standard to deal with vagueness. And why is there a problem with vagueness? Is simply because you can have overreach. The application of the section depends on the whims of a person who decides that it applies or doesn't apply. The gentleman making porridge, the gentleman refusing to make porridge. If I disarmed somebody who is perhaps drunk and I assume that he is becoming a danger, and it is 6 p.m. and I have nowhere to take the weapon that I have taken from him, I maybe have to hold it up in the air shouting that, you know, I have just disarmed this person, I'm not committing an offense. There's a big problem in our assessment with that provision. So, Mr. Chairman, it is the contention of the accused person that that offense is written in words that clearly show that the people who drafted it had run out of the clarity. Then they just said, let's just also put a net and see what else we can catch. We want to catch Nile perch, but let's put a net. If we also get mokene, we get worms, we get stones, it's okay. Let's just catch everything. But the whole intention was we wanted to get Nile perch. So, Mr. Chairman, honorable members, it is our contention that there is a question that arises with regard to section 128(1)(f). And the question that I will pose to the court is simply this: whether that section 128(1)(f) of the UPDF Act is defined in terms of, and therefore consistent with, Article 2812 of the Constitution. Honorable Chairman, the General Court Martial cannot answer that question because, as I said earlier, the role of answering these questions is the preserve of the Constitutional Court under Article 137(1). We trust that the Court Martial, as part of the UPDF, is a law-abiding citizen institution, which is why I referred to the attributes of the force, which must be professional and disciplined, and is aware that it must subordinate itself to the provisions of the Constitution will find this question one that can be referred for interpretation. Mr. Chairman, there is another question that we would like to also pose. And it's a question that has arisen here severally, but continues. And it is so fundamental to the trial of especially the two civilian gentlemen that it's imperative that it be addressed. Mr. Chairman, again, Article 28, Sub-Article 1, spells out the standard that is expected, that is required, from which there can be no derogation as far as a fair hearing is concerned. Fair, speedy, public hearing before an independent and impartial court. Independent and impartial. The cases, Mr. Chairman, that have dealt with the issue that I am addressing you on, the trial of civilians, are many. Captain Amon Biarugaba is one such case, 2015. Attorney General, Uganda Law Society versus Attorney General, 2005. Attorney General and Joseph Tumushabe, 2005. Michael Kabaziguruka, 2016. They have all said the same thing. And that thing is that with the setup that exists in the structure of this court, it is impossible for there to be a fair hearing. They have addressed questions of independence. They have addressed questions of impartiality. And I say this, Mr. Chairman, with all the humility I can and all the respect I can, but taking you back to the attributes of the force being subordinate to civilian authority. If the judiciary has said this is the position, then the force and its organs must subordinate themselves to that position. Because to do otherwise, Mr. Chairman, is to say that the force, that its organs, that the officers and men, the wonderful officers and men that constitute that force, can rise above the Constitution. If that route is taken, if that view is entertained, if that thought even crosses the mind of anybody, then the entire 150 words of the preamble that I spoke about are useless. We head right back into tyranny. You must distinguish yourselves from those forces that did not abide by the Constitution. Mr. Chairman, in light of those decisions, the ones I have cited, and I know my land friends will say one of them had a stay. It is true, it has a stay. It is a stay on implementation, not on interpretation. And when you read Captain Amon Biarugaba, the court there was very clear. Until the apex court has pronounced itself on the interrelated issues. This is a paragraph dealing with Kabaziguruka. Michael Kabaziguruka and Attorney General, as well as ULS and Attorney General, both of which I have cited, remain good law for the present purposes. Mr. Chairman, the law now is, as interpreted by the Constitutional Court, that we can't be here to deal with civilians. Even if we want to, we can't. We can't. Unless we are elevating ourselves above the Constitution. If we are, then we can be here. But if we are not elevating ourselves, then we must abide by what those decisions say, until there is a contrary decision. There is no, the stay, and I'm sure my learned friend will refer to it, the stay does not remove the interpretation. And the importance of the Constitution, I don't know what words I can use to express how important it is to abide by the Constitution. Mr. Chairman, the question I would like to frame, I am proposing be framed, is this: whether in light of the decisions of civilian courts, both the Constitutional Court and the Supreme Court, regarding the trial of civilians in the court-martial, the conduct of the General Court-Martial as an organ of the UPDF to try two civilians is consistent with Article 2082, the one on being subordinate to civilian authority, 128(2), Mr. Chairman, 128(2) is that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure the effectiveness of the courts. Effectiveness of the courts includes its judgments being binding, being applicable to everybody, until there is a contrary position. Michael Kabaziguruka was decided about 4 or 5 years ago. There has not been a contrary position. I would pray, Mr. Chairman, that that question also be allowed. We had proceedings, I'm still in Article 28, 1, on the impartiality, on the nature of the tribunal, and there is a question that arises about how impartial the tribunal, an organ of the defense forces which investigates an offense, charges the accused, tries the accused, can be considered impartial in any way. And this is not to say anything about the character of the fine officers and men who constitute the court. It has nothing to do with their individual, it's the institution. how can you be a judge in your own cause? How else can you find prejudice other than being a judge in your own cause? The charge sheet tells us about offenses relating to the defense forces. So when we ask that these matters move away from here and go elsewhere, we are simply following what the Constitution requires. Yesterday we had an engagement, we've had these engagements with the judge advocate, my good friend, but from this side and that side we're always having contestations. But just for purposes of impartiality, the panel, and also yesterday we went through what the panel consists of, but we found a regulation. This is just an example. Regulation 69. So yesterday we had an issue around the judge advocate and whether his views are binding or not, the advice given and so on. I'll address that shortly. But there is also another one which I want to give by example. 69.2 says that a court may adjourn, it is referring to the court martial, may adjourn at any time to consult the convening authority on a point of law. This court is supposed to be complete as a unit, discharging its work alone. Everybody who is a member of this court should be in the court. I checked on who the convening authority is. It's the High Command. Now, if a court will adjourn or can adjourn or is empowered to adjourn or is allowed to adjourn to consult the High Command, Mr. Chairman, Article 28(1) would have no place. But this regulation cannot apply above Article 28. Impartiality. So, we also pose this question. In the circumstances where we are, where the defense forces are the complainant, the investigator, the witnesses, the judge, is a trial before the court martial consistent with Article 28(1)? Is it? Can it be? We submit. That question needs to go. There are other factors dealing with impartiality. They have to do with the tenure, security of tenure, and so on. So in the other civilian side where we are maybe a little bit more familiar, we know that there is sanctity there. There are provisions that protect, that reinforce, they protect the judicial officer. It has something to do with the structure of the law. If indeed my learned friend's advice is binding, why is there a panel at all? So, Mr. Chairman, I want to pose a question. And the judge advocate's power is in Regulation 63(2). whether Regulation 63(2) and 69(2) of the UPDF Rules of Procedure Regulations are consistent with Article 28, 1 of the Constitution. Honorable Chair, Article 137 of our Constitution deals with the interpretation aspects, and the interpretation of the Constitution can be done in two ways, one by way of petition, the other way by way of reference. Even the one of reference has two limbs, one where the court itself considers it necessary if in its opinion there is a substantial question of law, but the second one is where the party to the proceedings requests for a reference. The word used is that the court shall refer. If any party to the proceedings requests, the court shall refer the question to the Constitutional Court for a decision. And when that reference is made, the case will be disposed of in accordance with what the Constitutional Court has guided. Mr. Chairman, a fourth question arises. Perhaps this morning also. And it has to do with Section 208 and Article 79(1) and 129(1) of the Constitution. And we want to ask the question whether that Section 208 is contrary to and convenes Article 79(1). Parliament makes laws for Uganda. For the governance of Uganda. Parliament doesn't have power to set itself outside, even 1 centimeter outside the boundaries of Uganda. We contend. 129(1) has to do with judicial power being of Uganda. So, in our view, Mr. Chairman, there is a question that we want to be interpreted. The place of Section 208 and Parliament. Honorable Chair, the framers of the Constitution, who incidentally also include one of the accused persons, envisage that at one point, as life goes on, there may arise a contestation between individuals and the state and organs of the state. That is what this 137 is all about. So, Honorable Chair, as I end, and my colleagues will supplement on other questions, but as I end, it is our contention that there are very serious questions that have arisen, which on the face of it, and this is the only requirement from the authorities, on the face of it require interpretation of the Constitution. They are not before a field court martial because that is the only time, that is the only court where you can't make a reference. For all other courts, you are allowed to make a reference. The party is empowered to make the request, and when they do so, the court shall refer the question. I pray that the 4 questions that I have posed be accepted and the reference be made on those and any others that my colleagues may add. Mr. Chairman, before I sit down, I also want to draw the attention of the court to another law, the Human Rights Enforcement Act. The Human Rights Enforcement Act is now Cap 12. And in Section 11, the consequences of derogating from non-derogable rights of a person are spelled out. Those who do so commit offenses. That's the first consequence. And as far as that consequence is concerned, the offense, even 10 years later, the person who committed it can be charged and is liable to sentencing up to 15 years. Brought to the attention of the court, that's the second consequence. The court is required to declare the trial a nullity. It's a heavy burden. It is a serious issue. So if we try civilians, contrary to Article 28, a non-derogable right, in the face of decisions of civilian courts to which we are subordinate, we are committing offenses. In fact, the court is required to declare that trial nullity, acquit, and discharge the accused person. The defense forces are capable of abiding by the Constitution and the Human Rights Enforcement Act. This court, I am sure, is capable of abiding by the Constitution and the Human Rights Enforcement Act. And I invite it to do so with utmost respect. Mr. Chairman, I'll invite my other colleagues to supplement, but that is our prayer this morning.
Thank you, Mr. Chairman. I'm adding, Mr. Chairman, for emphasis, and my colleagues will come with other questions. Mr. Chairman and members of the court, the first question that my colleague raised, and I agree with him entirely, was in respect to the uncertainty of the offense, whereby when you do and do not do, you commit an offense. So if we are crossing a road, essentially we have an officer saying don't cross, so that when you cross, you are disobeying an order. And you have one on the other side saying cross, yet when you cross, you're disobeying the other one. The point I'm making, Mr. Chairman, is that the necessity for a law to be clear, not only to members of the distinguished UPDF, but everyone, is just so that they know when they are conducting their affairs, when they are out of the law or within the law. And for emphasis, Mr. Chairman, again in the case of retired Captain Amon Biarugaba and others versus the Attorney General, Constitutional Petition 44 of 2015, the court addressed itself. I will just refer to a short quotation so that I can emphasize. Citing an American case, Colenda versus Lawson, the court was of the view that, as generally stated, the void for vagueness doctrine requires that a penal statute defines the criminal offense with sufficient definiteness that an ordinary person can understand what conduct is prohibited and not prohibited, and in a manner that does not encourage arbitrary or discriminatory enforcement. The rationale, Mr. Chairman and members of the panel, is that I should know whether to cross the road or not to cross the road is an offense. That was an example. But also, it is intended for an ordinary man. Mr. Chairman, in society we have individuals who are high up there. We have individuals who are in the middle who we ordinarily refer to as reasonable. They are not far off. And then we have the others who are lower, who in different aspects are referred to as the riffraff of society. The requirement for a law to be certain lowers itself to the lowest in society. The law should be very clear that an ordinary person, the lowest in society, is very sure about how they are going to conduct themselves. And that submission, that offense which says to do anything or not to do anything that constitutes or compromises security of the defense forces means that I am effectively at a cross junction. I don't know whether to go left, right, north, south, east, or west. The other one, the third question my colleague raised was in regard to the court being impartial. Mr. Chairman, the courts have recognized that military courts, like the one we are in, is intended to charge or to try officers for disciplinary matters. And of course, in our UPDF Act, there is a clause which brings in the civilians. But again, Mr. Chairman, the courts have made a pronouncement about the character of the military court, it being appointed by the executive, and therefore the officers forming the courts being subject to the executive. And the courts have made it clear in the case of the Second Lieutenant Ambrose Ogwang versus Uganda. It says that courts which have to try any civil or criminal matter must be independent. It's a command under Article 28(1), and the courts have said by virtue of the appointment of the military court is not independent. Mr. Chairman, we are not making or referring to the individuals who are before us or before whom we are standing, because we know that theirs is an appointment and they are executing the lawful mandate of their appointing authority. So it's not character of individuals, it is the institution, Mr. Chairman. The courts have said military courts are not independent and that they are military courts of the executive. They belong to the executive. Moreover, the charges they try are brought by the army. And Mr. Chairman, the court made reference to two sets of people. Those who are not subject to military law, I suppose like me, and those who are subject to military law, I reckon, Mr. Chairman, like yourself, Mr. Chairman, and the officers before us, because they are soldiers doing a national duty of protecting our country. But it said that persons who are subject to military law, like every other person in this country, enjoy fundamental rights which may only be limited in a manner allowed by the Constitution. He said that judges of independent courts cannot be under the administrative control of the authority that brings the charges. in this case, my lord, Mr. Chairman, rather, to the extent that the court is of the institution of the UPDF, and the offense that has come, one of which is to compromise the security of the UPDF. Again, it shows that the institution which placed all these gallant officers in their offices, which they're executing, is complaining before them. Put simply, because, Mr. Chairman, I'm a parent, I have a grown-up child, and I am offended by my neighbor, Mr. Kalibala, and I constitute a panel of my children to try the matter where Mr. Kalibala is accused, and I am the complainant. The likelihood that my children will find against me when I buy their clothes, the uniform, when I pay their salaries, is unlikely. But more importantly, in the eyes of Mr. Kalibala, he is not likely to see that as a fair process, because after all, the person charging him is one who I can direct to attend to me by instruction. And they must attend to me whether they want it or not, because as officers, you answer to the high office. Mr. Chairman, in that respect, the courts have taken note of individuals who are subject to this law and said that officers and militants of the Uganda People's Defense Forces do not, by joining the UPDF, surrender their rights and freedoms on account of joining the UPDF. We are thankful that today we have name tags. So if I turn around, I can see Mr. Walimbwa. He doesn't surrender his rights because he has joined national service in terms of the UPDF. He enjoys the same rights as I enjoy. So if in one dispensation, I am entitled to a fair, unbiased court, we are the same, all of us created in the same image, and therefore he's entitled to the rights I enjoy. So the courts have said that such rights and freedoms are available to the officers and the militants of the UPDF because they are available to all the other Ugandans who live in this country because they are inherent. The other point, Mr. Chairman, my colleague referred to Article 137, 5B of the Constitution. He alluded to a question which the court comes across and a question which is a request by the party. To be certain, Mr. Chairman, in this case, it is the accused persons from the amended charge sheet A2 and A3 who, through their counsel, are making this request. In that regard, the Constitution, which my colleague has repeated many times, is superior to the gallant force of the UPDF, commands all courts, including this one, to frame a question and forward it to the Constitutional Court. It does not allow this court the opportunity to determine whether there is sense in raising that question, because that is not its duty. To determine, upon response from our colleagues, that we can examine the validity of that question, or if in their view the question has been heard before, is to defeat the Constitution. Mr. Chairman, Article 3 of our Constitution says that anyone who acts in breach of the Constitution creates a very big offense, which perhaps, again referring to Mr. Walimbwa here, will now bring him under this court. It is treason. So, we are urging the court, Mr. Chairman, that once we raise the questions as we have done, the honor or the duty of this court is to put the question in proper wording and send them up. and not to determine whether the questions should be sent up, because it has been done already. There has been a request. Mr. Kalibala also referred to the Enforcement Act of Human Rights and said derogate from a non-derogable right, Mr. Chairman, is an offense. That should be section 11, and that is true. As officers of court, Mr. Chairman, we do have a duty, perhaps akin to that of the judge advocate, to advise the court. It is a duty we ought court as officers of court. What Mr. Kalibala did not say, Mr. Chairman, is that while people executing office have got immunity of office, this particular act waives that immunity. So the judge advocate, if it becomes aware that this court is deviating from he's not part of the court. If any of us became aware that we are deviating from a non-derogable right, we are committing an offense. And that offense is alive for between 10 to 15 years. Moreover, the defense that I was acting under instruction does not arise. Mr. Chairman, in 15 years, I would be nearing 65. So I wouldn't want my younger colleague here to keep it in his heart and after 14 years come against any of the distinguished officers there to say on the 14th of May, he took the view that they were derogating from a non-derogable right, because the defense of saying we are executing our mandate of officers established under an act of law will not be available to you distinguished members. That is the command of the law. Our request, Mr. Chairman, seeing that my colleague referred to the attributes of a force which is patriotic, which is disciplined, and a disciplined individual or institution agrees with established rules and principles, and given that the same command the force to subject itself to civilian authority, we do request that as commanded by Article 137(5)(b), which directs the court to submit the question, that when my colleagues have raised the questions, we do not engage, and most politely, with questions as to whether we should refer. Rather, we spend the other part of the day by getting the right language of the questions, which shall then be referred to the Constitutional Court to interpret as they are mandated to do under Section 130, Article Mr. Chairman, again, and for my colleagues from the state, led by the prosecutor, we just want to refer you, when I say you, my lord, it's not derogatory, the court, to Section 195 of the General Court Martial, which spells very clearly and succinctly the functions of the General Court Martial. My lord, Mr. Chairman, that section has 3 subsections, and the first subsection has got 5 paragraphs, none of which give this court power to interpret provisions of the Constitution or of any other law. We therefore request that we surrender to even that which sets in place this court, and the questions be crafted with the aid of our colleagues and ourselves and sent to the higher court for the necessary interpretation, so that if we are to return here following the finding of that court, we are sure that all the doubt we had about jurisdiction, about impartiality, about extraterritorial effect, which are now the paining points are handled and that we can proceed peacefully and in a manner that is subject and under established law. That is my request. I thank you, Mr. Chairman, and the members of the panel for listening to us. Thank you.
Thank you, Mr. Chairman and honorable members. The 4 issues framed by my learned friend here are well canvassed by my colleagues here. You will permit me, Mr. Chairman, to add on to those 3 issues. But before I do so, Mr. Chairman, just 1, 2, 3 minutes to reinforce the 2 issues, the first 2 issues on Council Kalibala raised with authorities only. The arguments have been adequately canvassed, and we are convinced this honorable court is persuaded by those submissions. Now, with authorities on vagueness of section 128, that is issue number 1. The vagueness, the uncertainty of that particular provision. The Constitutional Court has had occasion to pronounce itself on that particular matter in the case of Andrew Karamaji. I'll furnish you with a copy with you. Rather, I'll furnish you with a copy. Andrew Karamaji, Robert Shaka versus the Attorney General. It's Constitutional Petition number 5 of 2016. Kindly get the copy to the judge. But the point emphasized here, Mr. Chairman, the doctrine of vagueness in legislation. This is what they said on page 10. This is the Constitutional Court. The doctrine of vagueness is founded on rule of law. The doctrine of vagueness is founded on the rule of law, particularly on the principles of fair notice to citizens and the limitation of enforcement discretion. Fair notice to the citizen comprises a formal aspect, an acquaintance with the actual text of a statute, and a substantive aspect, an understanding that certain conduct is subject to legal restrictions. The crux of the concern for limitation of enforcement is that the law must not be so devoid of precision in its content that a conviction will automatically flow from the decision to prosecute. The threshold for finding a law vague is relatively high, and this is what they set as a standard. The factors to be considered in determining whether a law is vague or not: A, the need for flexibility and the interpretative role of the courts, that is number 1. 2, the impossibility of achieving absolute certainty. A standard of intelligibility being more appropriate. That standard of intelligibility is critical and crucial. 3, the possibility that many varying judicial interpretations of a given disposition may exist and perhaps coexist. They cited the case of Nova Scotia Pharmaceutical. It is a 1992 decision which you find here. So the doctrine of vagueness can be summed up in one proposition. This is how they summed it up, the Constitutional Court. A law will be found unconstitutionally vague if it lacks in precision as not to give sufficient guidance for legal debate. That is, for reaching a conclusion as to its meaning by reasoned analysis applying legal criteria. The term legal debate is not used. The term legal debate is not used to express a new standard or one departing from that previously outlined by this court. it is rather intended to reflect and encompass the same standard and criteria of fair notice and limitation of enforcement discretion viewed in fuller context of analysis and the quality and limits of human knowledge and understanding in the operation of the law. The criterion of absence of legal debate, and so it continues and continues. And finally, Mr. Chairman, this is the decision they arrived at after analyzing all that. A statute is also void for vagueness if a legislature's delegation of authority to judges or administrators, like this General Court Martial, is so extensive that it would lead to arbitrary prosecutions. I need to emphasize this. A statute is also void for vagueness if a legislature's delegation of authority to judges or administrators is so extensive that it would lead to arbitrary prosecutions. Vague laws involve three basic dangers, and this is what we want to caution against. This is what they stated. Vague laws involve three basic dangers. One, they may harm the innocent by failing to warn of the offense. Ignorance of law is not defense, yet the law itself is vague. Two, they encourage arbitrary and discriminatory enforcement because vague laws delegate enforcement and statutory interpretation to individual government officials. Laws are usually found void for vagueness if after setting some requirement or punishment, the law does not specify what is required or what conduct is punishable. Also, an enactment is void for vagueness if its prohibitions are not clearly defined. Finally, Article 28(12) is very clear. It requires that an offense must be defined. That definition, in my view, must be clear enough to enable citizens to distinguish between the prohibited conduct and the permissible one. Any vague interpretation will lead to satisfy the requirement of Article 28. They refer to the case of Charles Onyango versus the Attorney General. So this authority by the Constitutional Court, which has got that primary obligation of interpreting the Constitution, is binding on this one. And it's very instructive in that when you look at Section 128, it opens the floodgates. It cuts the net wide offenses relating to security. And punishment, death. This is how serious it is. So a vague law to subject somebody to a death penalty is something that cannot be sanctioned by the existing constitutional order. And the reason we are asking, we need interpretation of the Constitutional Court about that particular provision. So that is the authority in regard to the vagueness of Section 128 relating to offenses compromising security. The other issue, the second issue, again I will cite the authority, the issue relating to subjecting civilians to martial law, which my learned friend here adequately canvassed. But the authority, and he cited a number of authorities. Cited the ones of Uganda Law Society, cited Amoni Yarugaba, and cited Kavazguruka and a couple of others. But the point I wanted to emphasize, there are two authorities that have come subsequent to the decision of Kavazguruka. The one of Amoni Yarugaba, which is 2022, and it was very, very clear. And on that one, there was an appeal. The one of Yarugaba. Yes, the Attorney General preferred an appeal against the decision in the Kavazguruka matter. But the one of Amoni Yarugaba, there is no pending. There is no any order of stay and no any other far order in that regard. My learned friend alluded to the fact that the other side may raise a contention that there was an order Kuruka case. That has also been succinctly handled by the Constitutional Court, which took a decision in that case. They have decided it. One, in the case of Amoni Byarugaba, but more sufficiently in the case of Semuju Abdul Nur versus the Attorney General, Constitutional Petition number 4 of 2018. The most recent one, it is, to be exact, it is the 3rd February 2023. It is as fresh as these charges before you. This decision, the lead judge, may his soul, Justice Kakuru, may his soul rest in eternal peace, had the occasion to reproduce verbatim the decision in the Kabasiguruka case. Summed them up, and he said, the constitutionality, no, I have carefully listened and considered the submissions of both counsel on the constitutionality of sections 2, 119 and 197 of the UPDF Act. I have also carefully perused the affidavits and so on and so forth. The constitutionality of the issues raised above were substantially raised and settled in the recent constitutional decision of Honorable Michael Kabasiguruka versus the Attorney General. That is constitutional petition number 45 of 2016. Then he said, I'll reproduce the declarations in extension for clarity. He highlighted them. I may not take your time, but they are very few. Yes? Yeah, just number 5. No. The General Court Martial established under section PS. No, number 2, the General Court Martial's jurisdiction is only limited to trying service offenses under the UPDF Act. Then he said, and 3, military law under the UPDF Act must be construed to exclude laws that are the preserve of the civil courts of judicature. I will come to that later when I'm raising another issue. But more specifically, number 4, persons subject to military law. No. 5, sections 119, 1H, subsection 1 of section 179 of the UPDF Act are unconstitutional as they are inconsistent with Article 28 of the Constitution. That is a finding which is well captured in the decision of Kabasiguruka and reproduced in a number of those decisions. And they had occasion to make this finding after listening to the submissions of the state that in the Kabasiguruka matter there is an appeal, there is an order of state. This is what the Constitutional Court said after listening to the submissions which are likely to come from the other side when they are replying. This is the response and the finding of the Constitutional Court. The above authority is good law, and I am bound to follow it. We are well aware that the above cited decision is currently pending appeal at Supreme Court. Until the Supreme Court decides otherwise, the authority is still good law. The fact that gave rise to this petition are almost on all fours with those in Honorable Kabasiguruka's case. Applying the above authority, I find that the petition is on all fours. The petition is therefore allowed on that account alone. The same declarations and orders in the Kabasiguruka petition apply to this petition. This is as of recent as 2023. So, this court, I'm afraid to say, its hands are now tied. It has no choice but to go by the declarations in the Kabasiguruka decision and reinforced in the decision of Semuju and Byalugaba and others which have come subsequent to the one of the submission I will make here. Again, in emphasizing the point Fred Mpanga here has raised of Article 3, any attempt by this General Court Martial to proceed with the prosecution in total disregard of this finding of the Constitutional Court, with all due respect to the General Court Martial, it will be treasonable. It will amount to treason for this General Court Martial to proceed with the prosecution, with the hearing of the matter, in total disregard of this, because the Constitution, Article 3 is very, very clear on observance of the constitutional order, respect to the given constitutional order and the interpretations given. So I urge you, Mr. Chairman, and members of the panel, not to commit treason by proceeding with this matter. Now, Mr. Chairman, with your permission, I beg to move and frame three issues. The first issue, in addition to the ones, the first one is about the propriety of the proceedings, the charge sheet canvassing Mr. Chairman. Mr. Chairman, whether the trial premised on arrest and rendition of accused persons from Kenya in total disregard of the extradition law and other international laws, and on the basis of a memorandum of understanding which is not within the framework of the extradition laws, amounts to a violation of Article 28 of the Constitution. Mr. Chairman, in your finding this morning, you indicated that there is an MOU between the government of Uganda and Kenya to exchange people presumed to have committed offenses, which obviously is not premised on international law or the existing extradition acts or laws of both countries. So that is a matter which requires constitutional interpretation. Can there exist an extradition treaty outside? No, not a treaty, an MOU, yet the law provides for an extradition treaty. And isn't that a violation of Article 28 of the Constitution, which guarantees the right to a fair hearing and other relevant provisions? So I don't need to labor so much because we argued out that point earlier on. I would like to adopt the submissions we made earlier on about rendition in violation of the extradition laws. So I would like that matter also to be referred to the Constitutional Court. The other issue, Mr. Chairman, is the jurisdiction of this Honorable Court to deal with cases under the Firearms Act. Mr. Chairman, in this Kabaskuruka case, which is again reproduced in the subsequent decisions which I've just made reference to, particularly the one of Semuju. So, clause 4, paragraph 4 of the decision. No. Paragraph 3. Military law under the UPDF Act must be construed to exclude the laws that are the preserve of civil courts of judicature established under Chapter 8 of the Constitution. And Mr. Chairman, this was a reinforcement of the decision in the case of Dr. Chiza Besigye, the very person before you here, in Constitutional Petition number 12 of 2006, where it was adequately, again, handled by the Constitutional Court, that the offense is not the one whose particulars appear in the charge sheet. The offense in the charge sheet is under Section 3, by then it was Section 3, now Section 4 of the Firearms Act. That offense does not fall under Section 119. I'm sorry, it may not be that clear, the photocopying was not clear, Mr. Chairman. That offense, Section 3.1 of the Firearms Act, which is now Section 4 of the Firearms Act, and it canvasses count 3, 4, and 5. That offense does not fall under Section 119 of the UPDF Act. The offense of unlawful possession, ordinarily the monopoly of the UPDF forces. They said this offense is neither defined by any law in our statute books, nor has the sentence for it been prescribed. The said amendment of the charge, there was an amendment to the charge sheet, is clearly not helpful. they went ahead to say that government or UPDF attempted to come up with instrument number 13 of 2006, ostensibly I think to address that lacuna. Uganda People's Defense Forces, arms, ammunitions, and firearms, to define that phrase, monopoly of the defense forces. The court said that instrument was also redundant. And the beauty with this, my land friend here was still the judge advocate, was involved in this matter and is fully aware of the facts in this particular matter and all the attempts that were made to address those legal challenges. In other words, their finding was that you cannot widen the scope of Section 119 to bring into operation the provisions of the Firearms Act or any other law, including the Suppression of Terrorism Act, which is a preserve of the civil courts. That would be overstepping the mandate of the General Court Martial. I can say the incarnation of the same here in this very charge sheet. So what ordinarily ought to have been done is to define that animal, which clearly, the animal code offenses which are ordinarily a monopoly, no, weapons rather, weapons which are ordinarily a monopoly of the UPDF. Up to now, ever since this decision was made, the Besigye decision, this animal is still anonymous, undefined. And the attempt to do so in this instrument were also declared futile. So, Mr. Chairman, unless and until that phrase is unpacked and clearly dissected and explained, this General Court Martial cannot try offenses under the Firearms Act. So we would like that issue again to be also canvassed by the Constitutional Court. Finally, the issue I would raise is whether the arrest, conviction, and the detention of Counsel Ernest, one of the defense lawyers, amounts to violation of Article 28.3 of the Constitution. Mr. Chairman, Ernest is on record up to the present moment is one of the defense lawyers. And I'm glad when we raised it here and said, how do we cause the appearance of Ernest to execute his duties as per the instructions given to him and as per the record? There was preponderance of doubt. I read it on your mind. If I read you right, correct, Mr. Chairman. You said, is there a precedent to this? Did it happen that a person convicted can also come here? Then the judge advocate was of similar doubt. The only forum where that doubt can be cleared is the Constitutional Court. And the Constitutional Court has had occasion, this is the last authority I'm citing, this reference. In this case, it's one of the locus classicus case on rights, fundamental rights, Article 28. Uganda Law Society and Jackson Kalibala versus the Attorney General. The lead justice, I think, was Vagueness again. They gave a purposeful interpretation. Of course, this is the command of the Constitution and rules of interpretation to Article 128. Article 28 rather. Each and every of the above Constitution, each and every of the above, rather not of the above Constitution, each and every one of the above constitute what the right to a fair hearing means. It was never intended that this would be an exhaustive definition of the right to fair hearing. Article 45 of the Constitution provides human rights and other freedoms additional to these rights. Mr. Chairman, during the trial here, during the hearing of the prayer we made about the appearance of our colleague, Ernest Chiza, the judge advocate here indicated and said, but you see, Article 28 talks of the right to legal representation. It does not specify the numbers. The answer lies in this decision. That Article 28, which talks about the right to a fair trial, is not even exhaustive when it talks about those key elements. It's the reason the CA had to insert Article 45. That there are situations that may arise that would warrant one more than what you can even see. Why Ernest Chiza is indeed needed in this case can only be answered by the person who gave him instructions. He knows the reason, and he should be facilitated to prepare his defense. And one cannot say, just especially from the other side, from the judge advocate, that what role is he going to play when the accused person has got over 30 or 40 lawyers. The prerogative rests with him to determine who should be there, who shouldn't be there, and to have a lawyer or lawyers of his choice. That is the language of the Constitution. Ernest Chiza remains his lawyer of choice for a reason which should not be derogated, because that is a non-derogable right, the right to a fair hearing. Article 28 and 44 is a non-derogable right. So I reiterate the prayers made. I will not go into other issues. I beg that Mr. Chairman and honorable members that you proceed to do what is commanded by Article 137 to refer this matter to the Constitutional Court. I beg to move.
Please, Mr. Chairman, I'll be brief because my colleagues have expounded on most matters. But I want to begin by reminding us that in Article 5 of the Constitution, Uganda is declared a republic. And then move on to cite several characteristics of a republic. Characteristics of a republic: there must be, the people must be the source of authority. And that's what the Constitution of Uganda says. Everything is done in the name, for, and in the name of the people of Uganda. The people must also elect their representatives to make laws and serve their interests. And that happens through Parliament. In a republic, there must be rule of law. Law that applies to everyone equally. And this will be very important in an issue that I'm going to raise. In a republic, there is protection of rights. The government protects the rights of citizens. Another feature of a republic is the absence of a monarchy. A monarchy is where leadership is hereditary and to families. There is also equality of rights. All citizens have equal rights. Those are some of the characteristics of a republic. Uganda being a republic and having representative democracy and having a constitution that protects the rights of the people, this court-martial is enjoined to follow the Constitution. So what does the Constitution say on the reference of constitutional questions to the court, to the Constitutional Court? I want to read Article 137, subsection 5, where any question as to the interpretation of this Constitution arises in any proceedings in a court of law other than a field court martial, and I want to pause there and say this is not a field court martial. This is a general court martial. So this section applies to this general court martial. The court may, if it is in the opinion that the question involves a substantial question of law, the court shall, if any party to the proceedings requests it to do so, refer the question to the Constitutional Court for the decision in accordance with clause 1. So you can refer the matter of your own accord. But when it is requested by a party, the way now we are requesting you on behalf of these two gentlemen, Dr. Besigye and Mr. Rutale, you have no leeway. You are commanded by the Constitution to refer the matter to a constitutional court. The matter, as my colleagues have conversed, arose in the course of your ruling, Mr. Chairman. And I will not go to the questions they have already framed. I'll go straight away to a different question, the question of freedom from discrimination, in line with Article 21 of the Uganda Constitution. When there is no law to define who in Uganda chooses to bring civilians like Dr. Besigye and Mr. Rutale to the General Court Martial instead of the courts of judicature, that subjects them to discrimination, and it is our prayer that this question be added, whether it is discriminatory to bring civilians to a general court martial instead of a court of judicature, especially without a defined authority that makes that choice. Because the question we are asking, who made the choice? We do not know. The charge sheet does not tell us. There is no gazette notice to tell us that XY is the one who made. We can only guess that authorities within the military decided. But it's an authority we cannot touch. It's an authority we do not know. And in a democracy, discretion and power is limited by the Constitution and laws. There's nothing in this Constitution prescribing how, who and how the decision to bring civilians to a court martial is made. Therefore, when they are brought at the whims of people we do not know, authorities not defined, it becomes discriminatory. We want the court to answer whether indeed this is discriminatory, as we state from the bar. My colleagues have already argued that the fact that the offenses for which they are being tried are not defined is again something the Constitution abhors. And I've already said constitutions exist to limit exercise of power. So if exercise of power is not limited by the Constitution, then it is unconstitutional. And the Constitutional Court needs to answer that question. I also want to add one more article of the Constitution, that Article 79 of this Constitution of Uganda, which mandates Parliament to make laws. It defines the functions of Parliament, and it says that subject to the provisions of this Constitution, Parliament shall have power to make laws on any matter for the peace, order, development, and good governance of Uganda. Except as provided in this Constitution, no person or body other than Parliament, shall have the power to make provisions having the force of law in Uganda, except under authority conferred by an act of Parliament. And then finally, Parliament shall protect this constitution and promote democratic governance. So the exercise of power to cause civilians to come to a general court-martial are not defined in any law, and therefore there are unconstitutional and against Article 79. And we are asking you, in framing that question, whether we can have exercise of power without, or discretion without limit, is unconstitutional. Add Article 79 to that request. Finally, everybody, including yourselves, is obliged under the Constitution of Uganda to obey it. So we are urging you to stand up for the Constitution and to refer these questions to the Constitutional Court so that we can have finality. Maybe somebody may argue that because others have taken the questions to the court, to the Constitutional Court, they have already been answered. I want this General Court-Martial to note, we have raised questions that have not been raised before. There are some that may be similar to those that have been raised earlier. Questions of discrimination, questions of a lawyer who is part of the team being arrested and detained and therefore not available, questions of fair process. There are various, quite a number of questions that have not been asked before. Also the fact that there is nothing in the Constitution that gives the UPDF judicial authority over civilians. And therefore, any act of Parliament conferring judicial authority on civilians to the General Court-Martial is unconstitutional. So it's a question the court will have to determine, to declare the UPDF Act unconstitutional to the extent that it confers judicial authority on civilians to the UPDF. And Mr. Chairman, when you are reading your ruling, you actually found that it was not, you alluded that it was not unconstitutional. The authority to interpret the Constitution is exclusively to the Court of Appeal, sitting as a constitutional court. So it will be useful even to you and the General Court-Martial to hear an authoritative interpretation from the Constitutional Court as to whether you indeed can try any civilian in Uganda. The issue of extradition from Kenya, not extrajudicial rendition, not extradition. Extradition connotes a court process where orders are made. In this case, there was no court order. We urge that those issues are more than enough, and I'm asked by my colleagues that since we have exhausted, we end it here to give the prosecutor the chance to make a rejoinder.
Chairman and honorable court members, before we put in our agenda, we wanted to have a copy of the ruling which you made. Because why the accused persons could not take a plea was that some issues arose out of that ruling, and therefore they need to be interpreted. And we also request that you provide us the case of Andrew Karamaji. So we don't have a copy, just for...
Maybe all the authorities cited.
Yeah, you can give all the authorities that you cited, but there are some which we have in our chambers there. Then we also pray for 30 minutes so that we can respond to the concerns.
That one registrar can handle. Ladies and gentlemen, the court is adjourned for 30 minutes to give time state to peruse on submissions that were raised by the defense.
Communicate.